This call is now being recorded.
Okay, it's Randy Rosado here again. This is November 10th. This is a continuation of episode 5, so maybe it's episode 6, but I'm still talking about this crazy unlawful arrest and all the documents and cover-ups that they've tried to do after the fact. So between recordings here, I had a discussion with my mother, who knows the case as well as I do, and there's a lot of confusion, and that's what they wanted. But it just, something that came to my attention was, if you look at the Freedom of Information Act request by the Orange County Sheriff's Office, they just happened to reply to me on August 24th, 2021, and some of the documents in that reply were the arrest affidavit and the arrest warrant from St. Lucie County, and it was actually faxed to them exactly 5 years earlier to the day on August 24th, 2016, while I was in New York custody. And this is kind of interesting because the arrest warrant, right, usually you need an affidavit, or an arrest affidavit, to actually get an arrest warrant. So one precedes the other. Well, this is interesting because the arrest warrant that was faxed was allegedly, well, it was signed by a St. Lucie County judge on August 23rd, 2016. But then the sworn arrest affidavit that created that warrant wasn't signed until August 25th, 2016. So how does a judge, or is it 25th? Maybe it's 23rd. Maybe it's just scribbled. Maybe I'm just thinking too much on this. All right, maybe it was the same day. It's hard to say. Is it the 23rd or the 25th? Either way, this was allegedly served on me while I was in New York custody, which isn't the case. I didn't even know about the St. Lucie case until months later. Anyway, the bottom line is, if you look at that document, you'll see that it's just coincidental that the FOIA request response from the Orange County Jail was exactly 5 years to the day after this Trish Becker from the St. Lucie Sheriff's Office Judicial Services Warrant Unit, whatever, sent this fax over to Orange County. And this is what they used to justify my incarceration there and my extradition. So again, it was 2 months after I was already being held. It was used to get the extradition warrant. And again, it clearly shows that the June 28th day of my arrest was scratched out, and September 7th was the day of my arrest. Matter of fact, it says this Robert Sawchuk or whatever of the state of New York in Orange County says he received the warrant on August 31st, 2016, and he arrested me on September 7th, 2016. How do you arrest someone that's already in custody in your jail? I never met this guy or heard from him, yet they're saying he arrested me on September 7th, 2016, when all the other proof, including the arraignment, show they entered my home on June 28th, 2016 and arrested me. I mean, is anyone looking at this stuff? And this is my frustration. This stuff is so blatant, and no one cares. I'm rotting away for this stuff that Joel Soucy did, and now in St. Lucie I'm dealing with this other guy, Gonzalez, right? These are the guys who filed the paperwork and got probation, and I'm getting a life sentence over it. So this is insane. But the final thing I really wanted to share, going back to the entry in New York, is, again, this is a question I asked the appellate court. This is a question I asked any legal expert out there to help me, and please just give me an honest answer. Maybe I don't have, maybe I'm crazy and there's not something here, but does a Florida judge have the authority to rule on the entry of a New York residence, especially when it was made by federal agents? Because I know this much for sure, that the Florida statute 933.09 and 901.09 have to do with making an entry based on a search warrant or an arrest warrant. Okay? Now, the New York version of that is New York Criminal Procedure Law 120.80. That's, again, the proper way of executing an arrest or a search warrant in New York, where it happened. And then just to be safe, because it was federal agents involved, I said, let me get the federal law, which is U.S. Code 18, United States, or whatever, USCA 3109. And that covers the federal law regarding that, and they all say the same thing. Without exigent circumstances, you cannot enter someone's residence without knocking and announcing yourself, when they clearly admitted that they let themselves in using a key they got from the landlord. They broke into my house, and even though it was with a key, I showed federal law that says even if the door's unlocked and you let yourself in, that's still considered a break-in because it's an unauthorized entry. And I'm not going to say all the laws I used. I cited cases for New York, for Florida, for the federal law, just to support the same thing, that even if there was a warrant, which we know there wasn't, because the arraignment in New York clearly says there was no warrant, but even if there was, like this Judge Richards is trying to say, and like Robert Nichols is trying to say, with these lies about the NCIC and all that crap, it didn't exist. But even if the warrants were in place prior to them coming into my home and arresting me, the law says they have to be executed a certain way, and they can't just run into your house without emergency circumstances, and that's what they did. Point blank, bottom line, yet, the appellate court wants nothing to do with it. I don't see how a Florida judge has jurisdiction over this New York entry. I don't see how they could have used anything that they got from that search, because it was all illegal. And they went through my wife's computer. They found a woman who did work for us, and they made her a big witness and got her to lie. They would never have even known about Heather Morehouse unless they found her through the search of my wife's computer, and then they didn't let me face her at trial. They used a recorded testimony of her where she lied through her teeth, and this woman did not work with us with any of the dates in question. She worked with us way after the fact, and she was a friend. She used to tell us how much she loved us. We were friends, and next thing you know, the state got her saying all kinds of lies, because the state will get these people to say anything because they threaten you, they scare you. They tried to do it to my wife. They tried to get her to testify against me, regardless of whether or not we're protected by husband and wife privilege, or we were. And that's part of the evidence code. But, the court-appointed attorney that was set up to basically help the state convict me said, no, well, that doesn't matter in your case. There's ways around it. So, I don't know. Maybe I'm crazy, but I would really appreciate some kind of legal mind to take a look at this stuff and really, tell me I'm crazy, and tell me that what they did is justified, because this is just rogue police stuff. This is a kidnapping. It involved the FBI. It involved the Village of Goshen Police Department, Ryan Rich and his people. It involved members of the Orange County Sheriff's Office and the State Attorney's Office, Gary Cooper, and people that were involved. And most importantly, it involved the state of Florida, specifically Robert Nichols, Robert Foley, who's now a defense attorney in Fort Myers, former FBI agent, former Lee County prosecutor. And James Miller orchestrated this. Matter of fact, before James Miller, the prosecutor was Michael Brown, who's now a judge in the same 20th Circuit. He's either in Lee County or Naples, which is Collier County. So, this involves some high-level people, man. I mean, I don't know why no one will investigate it, why these judges have so much power, why they can break the law, why these prosecutors, judges, investigators, FBI agents, why they can go and do all these crazy things, especially when I've got physical evidence. It's all there. I'm not making it up. See for yourself. And I just pray that someone will listen to this and put it in the right hands and investigate these criminals, because, and I'm not saying I'm locked up with a lot of innocent people, and that that everyone that no one's done anything wrong, but we're supposed to have these protections from the Constitution. There's supposed to be a process, and when the people who are supposed to be upholding the law are breaking the law in order to get a conviction, there's a serious problem, and that's what's going on every day, and it's disgusting. And that's it. So that's all I've got for now. But that's what happened when I got arrested in June of 2016. Here I am 5.5 years later, still wondering why these people can still do what they're doing and get away with it, because it's just nothing better than excuse my language, but it's just a shit show, and that's all it is. Anyway, thank you for listening. I'll talk to you soon.